Simpson Presides.
Your Honor, I apologize. The victim just went to the restroom, but she.
Okay, you may be seated, folks. Okay, we'll wait. It's on.
I'm sorry. Hold on.
I just want to make sure. I don't want her having to yell.
Yeah, see. Like, you know, just like.
Yep, got it. We could wait just one moment. I want her to get back from the restroom and seated and then bring him out. Nope. Okay. Now, you just say please. Just say please. I can be a much more pleasant person. Okay, good. May 29. We can bring the defendant back in. We're back in the case of the People State of Michigan versus Gerald Burns. Got it? All right, the defendant is present. You may proceed, Ms. Tan.
Thank you, Your Honor. Listen, before we took a break, I asked you, you had made a comment about how you couldn't take it. That's why you left in April. And I asked you what you couldn't take anymore. You started telling us about that. Could you please tell the court? And for how long was that going on? And how long were you together, counting the dating and the marriage?
6 years.
Okay. Thank you. I don't want to go into too many details, but I do want to ask you a little bit about what the emotional abuse looked like or sounded like. And did you?
I put them in the trash bag and hid them in the closet.
Were you?
Madison, when did that happen? So, I'm sorry. I just trying to understand. So you had one pair of shoes?
Shoes, but they were old. Bought me new shoes, which were slip-on Skechers.
And just because I'm trying to get it, those were the only shoes you had at the time? Oh, well, you're right. You're actually answering my question, but I want to. Those were the only shoes that you were allowed to wear?
Yes.
So you had one pair of shoes that you could wear? Thank you. Go ahead.
Thank you. Madison, you said you hid the other shoes in the closet. Why did you hide them? And what was your concern, if any, would happen if Mr. Burns knew that you intended on keeping the other shoes? You said there were things he wouldn't let you do. We've talked about some of them, like going places by yourself, driving cars, the phone thing. Were there other things?
There's one time
Did you feel like you could hang up on him on the phone and continue your walk? And what would happen if he came rushing home in your mind? Okay. And what would, I'm sorry, I didn't hear that last part. I apologize.
So, I'm sorry.
It's okay.
I just want to be clear. When he FaceTimed you that you had to come back, was he at home?
And you said that if you didn't obey essentially and go home and you had hung up on him and continued your walk, that he'd lash out, and then you were saying something else.
I was really trying to kick me out and threatened that several times. And then they take Benjamin from me.
And is that why you did as he told you to?
That a yes.
Yeah.
Oh, sorry.
It's all right.
Okay, and Madison, you had mentioned some sexual assaults. I don't want to get into details of those because they're not charged in our jurisdiction. But can you just tell us, generally speaking, when those occurred? So you get body aches,
So
and would this be during the time he would assault you sexually? Okay, in general. And you said you would ask him to stop. And when you say you asked him to stop, you mean you would ask
I
him?
do want to object because this is, again, we're talking about situations that didn't happen in this jurisdiction. I understand that people's attempt to elicit maybe, state of mind or reasonable fear, but I don't.
I'll sustain the objection.
Yeah, it's okay. We can move on. I was asking more for the timeline. I apologize. So around what, how many years ago, months ago? I'm sorry? Okay, thank you. Okay, so going back to May 5th of 2025, you're at Moss Children's Hospital with Benjamin. He's getting treatment. At some point, did Mr. Burns come to the hospital? Did he give you a reason as to why he didn't want her to come back?
he said that he just us parents that no one else needed to be in there.
Were there arrangements put in place of how and when you were going to be with Benjamin in his room and when Mr. Burns was going to be in the room? Okay. So were you in the room together with Benjamin?
Yes.
Okay. Before, we're going to get to questions about the assault, but before the assault happened, let me ask this. I'm sorry. So, how long, if you remember, how long had you been in the hospital with Benjamin when the assault happened? Total? Okay. And did the assault happen right when you got there or a couple of days or a few days later?
A few days after.
Okay. Leading up to the assault, did Mr. Burns engage in behavior that concerned you? Okay, can you tell the court about that, please?
He told me that he was feeling suicidal. He told me that he took half of a bottle of Tylenol.
And was that his first time talking about suicide? Okay, can you tell the court if that's happened previously? And so in the hospital, when he was threatening suicide, did you believe that he might actually kill himself? Do you need a break? Are you doing okay? Okay, all right.
You said you're fine? Okay, just listen. It's okay. If you need a break, it's probably good for me to walk so I can get up at any point in time, okay? So you just tell me, all right? All right, go ahead, Mr.
Thank you, Your Honor. Was the threats of suicide before or after the assault? And since Benjamin was there several nights, did Mr. Burns and you stay at the hospital overnight? Okay. Where were you sleeping? Together on the mattress? Did you want to sleep on the mattress with him? Did you end up sleeping on the mattress with him? Did you feel like you could tell him that you didn't want to sleep on the mattress? And when you say attitude, could you describe to the court what you mean by that? Okay, that's okay. Thank you. Okay. I want to talk a little bit about what more immediately led to the assault, okay? At any point while you were in the hospital room with Benjamin, did Mr. Burns touch you in a way that was against your will? Okay. Can you tell the court how that started, please?
Seemed kind of like touching my leg and like down the back area. I don't remember what his name was. They just had
Okay. And you said leg and down in that area. I know it's hard, but I need you to tell me what specifically, where on your body did he touch? Again, I know it's really hard. I need you to be very specific about where he touched you. Did he touch your genital area? Okay. What part of his body did he use? We're talking about initially to touch your genital area. Okay. Did his hand or his fingers at that point ever enter your vagina? Okay. Okay. Did you want him to touch you in your genital area? And you said you were pushing his hand away? And what happened after you pushed his hand away? Was he saying anything? What happened after he was touching your leg and your inner thighs, your vaginal area? What happened next? Okay. At some point, did he ask you to do anything with him? Okay, can you tell the court about that, please? Did you want to have sex with him? Okay. Did he stop asking? Did he ask one time? Okay. Can you tell the court a little bit more about that interaction, how it went? So he was asking you for sex more than one time. Was it more than 2 times? Okay. And did you have a response to that? Okay, it's okay. At some point during his asking you to have sex, did you change your mind and decide you wanted to have sex with him? Okay. Did you end up having sex? Did it occur again that he asked you to have sex?
May 7th.
Okay.
I just want to stop.
Okay. I want you to, as best you can, describe a little bit to the court how come you gave in. You were worried he might take your son or kill himself. Okay. And we've already talked about his threats in the past to do so. Sorry, just one moment, Your Honor.
Yes.
And did Mr. Burns, and I apologize again, I know this is difficult to talk about. Did Mr. Burns end up penetrating you? Okay. What part of his body did he use to penetrate you? I need you to please say the word. I know it's hard. And it's okay to say, I know we're in court, but with the court's permission. Okay. And when he used his penis to penetrate you, what part of your body did he penetrate? And did his penis go into your vagina past what we would call like the lips of the vagina, the outer parts of the vagina? Okay. And is that something you wanted him to do? Did Mr. Burns use any other part of his body to touch or penetrate any part of your body? We can go with touch first. Did he use any other part of his body to touch your body? Okay. Did he use any other part of his body to penetrate your body? And we've been talking about Mott's, as far as you know, Mott's Children's Hospital, is that in the state of Michigan and Washtenaw County? After, kind of the sexual penetration and what you've described to the court, do you remember, if Mr. Burns said anything to you? Would it refresh your recollection if I showed you a statement you made to police shortly thereafter? Okay. Your Honor, if I may approach, before I do so, I'm showing defense counsel page 4 out of 6 of the original police report. It has been shared in discovery.
So how it's gonna work is you're just gonna read through this part. You're not gonna read it to us, just to yourself, okay? When you're done reading it, just look up when you're done.
Okay, thank you. Your Honor, may I retrieve it?
Yes.
Madison, did that help refresh your recollection? Okay. Could you please tell the court if Mr. Burns made any statements after he penetrated you?
He said,
Thank you. I do have a couple of questions that I missed. I want to go back to. You said you moved out of his parents' residence on April 4th. Where did you go? And what was that? Was that shelter specific, or what was it a shelter for? And when you left in April, did you, again, I don't want to get into the details, but did you make complaints with other police departments reporting the previous assaults? Okay, thank you. Thank you. Nothing further at this point.
Cross-examination. Madison, are you good? Okay, all right. Cross-examination.
Thank you, Your Honor. Hi, Madison. My name is Chinaza. I'm with the Public Defender's Office. I'm representing Jerome, so I have a few questions for you, okay? All right. So you indicated just now that you and Jerome had been married for about 3 years, you said?
Yeah.
Okay. When's your anniversary? And you stated that your son went into the hospital on May the 5th. Is that correct? Okay. So when Jerome came to the hospital, how did he know you were at the hospital or that your son was going in for this procedure?
I'm sure.
Okay. So, but you knew he was coming to the hospital, right? Okay. And you guys, you didn't go to the hospital together? Okay. And so if that was May the 5th, that means 2 days later was going to be your anniversary of your wedding. Is that right? Okay. And Jerome bought you a gift. Did he bring a gift to the hospital for your anniversary? You don't remember if he brought you an anniversary gift or any kind of gift to the hospital? Okay. You don't remember accepting a gift and telling him how much you loved the gift that he had bought for you? Okay. So when you all were at the hospital together, and you were both in the room visiting your son, is that right? And both of you stayed there for that entire week with your son, right? And when you were there, you guys, you played games together? You and Jerome talked a little bit, I assume? You're in the room together? Okay. I want to go back just a little bit. You indicated that your son had to get an NG feeding tube, right? That was the reason for the admission. What was the reason for that? Why did he need a feeding tube? He didn't have one prior to that, right? Okay.
Calories throughout the day are just food.
Okay.
A few days I had him eat just as normal every day when he would eat, just to see how many calories he was getting, so they could adjust for how much he would need to once they put it.
Sure. And that's something that they were doing at the hospital? Okay. No, I mean the monitoring the caloric intake at the hospital. Okay. But isn't it true that part of the arguments or issues with you and Jerome is feeding of the baby?
I'm gonna check, Your Honor. I'm not sure how this is relevant to whether or not the assault happened.
Well, Your Honor, I think that it's going to go into some of the other allegations about the telephone and the excessive oversight that she alleged that my client had over her. We have a reason, or my client has provided me with some information as to what may have led to some of those things or some of those discussions.
Your Honor, I'm concerned not only that it's not relevant, because quite frankly, it's not. I'm also concerned that this is all going towards, defendant has multiple times threatened, talked about taking the child away by whether legal means or unlegal means, but we certainly had discussions about family court. This seems like an attempt to make this victim look like a bad mom, and it's not only not relevant, but it's highly inappropriate for this setting.
I mean, that's by no means what I'm trying to do. I'm just
And I'm
trying
not
to.
doing that on counsel. I believe that's defendant's intent.
So what would I do with what you're attempting to try to, tell you what, I'll be able to sort it out. I'm going to overrule the objection. I'm going to give you a little bit of leeway.
Understood. Okay.
Thank you.
Thank you, Your Honor. So Madison, my question was just basically, I guess the bottom line is this issue with caloric intake, it was sparked by weight loss of the child, right? Okay. You know how much weight he lost? Okay. Now, do you recall some of the arguments between or some of the issues that, well, let me just ask it like this. You made some statements stating that my client would force you to put your phone on a dresser or a table of some sort, correct? Okay. And isn't the reason that he did that because he complained you were on your phone too much? Okay. He never complained to you about not feeding the child in the manner in which he was supposed to be fed? Okay. What about the allegations or issues that you guys had in regards to infidelity?
I'm going to object, Your Honor, that assuming that's not an evidence. So unless there's...
Well, except that it's his accusation that that Madison actually testified to peripherally, but so I'll overrule the objection. Go ahead.
Thank you, Your Honor. You stated earlier that he would always accuse you of cheating on him, right? Or talking to other guys. I think that was what you said. And isn't it true that he has confronted you about talking with other guys and cheating on him? Okay. And isn't it true that you had multiple telephones, cellular phones? Okay. You had 2 cell phones. Okay. And you talked about you having to do these check-ins and having to keep your phone on the dresser. But my client goes to work, right? He would leave the home to go to work. Okay. And you stated that you lived with his parents at their home. And they also go to work. Is that correct? Okay. And you also testified today that your son goes to school. Okay. So at times you'd be at home by yourself or my client wasn't always with you in the house. Is that right? Okay. You also talked a little bit about him not allowing you to see your family who lived in Livonia, but he never told you couldn't go to their house, right?
Actually.
Okay, but your testimony today was that he said he wouldn't take you there because he didn't have the time or the money to drive you there. Okay. So what would happen if your family were to come visit?
Mother doesn't have a license and my grandma's got health problems. She doesn't get a car.
Okay, so they just wouldn't come or he wouldn't let them come? You said that he would let them come visit.
He told me that they could.
They did not. Okay, so they did not come visit. All right. And speaking of license, that does bring me to the next question. When you first met my client, you didn't have a license, did you? You did?
Tickets.
Okay. All right. And Jerome he took you to go get your license back when you did get it back, right? Okay. And at one point in time, you had a white Dodge Charger. Okay. But he had purchased that car. I mean, it was your car to drive.
It was his, and he was just giving it to me.
Okay. And what about your online bank accounts? You had some online bank accounts like through Chime and other companies?
We shared one, and then I ended up going back on my Chime.
Okay. All right. So I want to go back to the hospital. When you all were in the hospital, you said you guys played Uno together. You talked. Now, when my client, you stated today, or you testified today, that he asked you for sex. Okay. And is your testimony today that you did not tell my client that you would do it one last time with him?
But I was scared.
You agreed, you told my client that you all could have sex one last time, right? Oh, and hold on. The one last time is because you knew that my client was filing for a divorce, right? You did not know that. Okay, but you had left the home and obviously did not have intentions on coming back. After you all agreed to the one last time, isn't it true that my client asked you again whether or not this was consensual and that you were sure? Okay, but you said yes when he said that, right? Okay, and inside of this hospital, they've got call buttons next to the beds, is that right? They've got call pull cords in the restroom, is that right? They've got call pull cords in other places inside of the hospital room, right? Okay, so much so that I think you accidentally pulled one of those call cords at one point in the hospital, yeah.
The bathroom about turning the light on first.
And pulled the wrong thing, okay. And my client didn't get upset with you or loud with you in the hospital, right? He did? And what did you do when he got loud with you? Okay. But when you were in the hospital, I'm assuming that doctors and nurses and orderlies or whatever the other titles I may be missing, they came in and out the room regularly, right? Okay. And there's no lock on the door inside of the hospital room, right? Okay. When did you report? You did not report this incident. You said that this happened on the 7th. Did you give us a date? I don't know if I took note of that. I apologize. You indicated on the 7th that this had occurred, but when did you talk to someone about it? On May the 10th. Okay, no, so let's just do this. When I ask you a question, just answer.
Well, what was your statement? It was on May 10th because
I was going to say something before, but I finally had a chance to go for a walk. And I was able to help someone.
you were able to go for, go ahead. Okay, so you're at the hospital, you went for a walk, and then that's when you told someone. You were still at Mott's at that point. All right, go ahead, Counsel.
Thank you, Anna. Based on what you're stating right now, does that mean that you never left the room You left the room, the hospital room without Jerome, right? Yes or no? Okay. You left the room to go possibly get coffee? Yes? Okay. You left the room to possibly go to the cafeteria. Is that right? Okay. So all the food that you ate that day was ordered and brought upstairs to you? Okay. How about this walk that you said you went on the 10th? Had you not gone on a walk from May the 5th all the way to the 10th, the entire time you were there? Okay. You also.
You're saying that, I just want to make sure.
That's
Again, when you're answering no to the previous question, that meant you had not prior to that point in time gone on a walk, right? Okay. I got it.
And the entire time you were in the hospital, you had your phone on you, right? Okay, but you had your phone on you. My client didn't confiscate your phone, either of the two phones that you have. You had both of your phones, right? And you talked to people on the phone or you texted people while you were there, right? Okay, but at some point while you were there, were you having conversations with people on your phone? Okay. You also reported, you testified today that your father's celebration of life ceremony happened while you were there, correct? Yeah, and you had someone come and pick you up, right? Okay, so how did you were able to arrange that ride with that individual without talking to them, texting them on the phone, or communicating at all? You communicated with her on the phone, okay. And there were times where you and Jerome had left the hospital together. Is that right?
Just you wouldn't let me stay in the hospital by myself.
He wouldn't let you stay at the hospital by yourself. So you and Jerome went to go get the air mattress. He took you to La Casa as well, right? You did not go to the shelter at all during that 5-day period you were in the hospital? You don't remember my client driving you to La Casa and sitting outside for 2.5 hours while you went in there to check in? I can't hear you. Okay. How about, you don't have to do check-ins with La Casa when you're staying in the shelter? You had to do check-ins with them, right? And you were required to report to them to let them know your whereabouts and your well-being and things of that nature, right? Okay, and you did that on your cell phone, right? Okay. So you went to your father's going home or celebration of life ceremony. What day was that? Okay, it was before the 10th. So, but it was after the 7th, right? Okay, so your father's going home ceremony was after the 7th, before the 10th, so maybe the 8th or the 9th, right? Okay, and you went by yourself. That's what you testified to today, right? Someone came and picked you up and they took you to the celebration of life and you were there for however long that took and then you came back. Is that correct? Okay. And there were a number of times that Jerome left the hospital without you. Is that right? Okay, so there were times where you were there by yourself. He wasn't with you the entire time you were there, right? Okay, I don't have any questions. Well, give me 1 second, Judge. I do have a few more questions for you. Now, Jerome has never done anything to your son. Is that right? Okay, he's never abused your son, assaulted your son, or anything like that, right? Okay, and when you said that he tried to, or he told you that he had taken a number of pills, what day was that? Okay, but it was sometime while you were in the hospital, right? And doctors and nurses and CNAs and other people walked into that room, right? And if you were really concerned about the pills that he took, you didn't tell anyone, you didn't report to anyone that he may have. Okay, so you didn't believe that he had done that. Okay, no further questions, Your Honor.
Any redirect?
Okay, Madison, how you doing? A few things I wanted to follow up on. So council asked you about essentially telling Mr. Burns that, you know, giving in, saying, I'll do it one last time. And you were saying that you agreed because you were scared. So you did it because you were scared. Can you tell us more about that, about what was going through your mind and what that fear was?
And we said because it was our anniversary that was the reason that we had to, because we were still married. Sure, it wasn't long.
And you asked if Mr. Burns has ever abused your son directly, Benjamin, and the answer was no. Has he ever assaulted you or done things to you in front of Benjamin? Okay. Please tell
Your
the,
Honor, I want to object to that. I think that this is still leading towards the out-of-county offense.
Well, actually, you raised the issue. I think you've opened the door to that regarding abuse. So if a parent something is happening to a parent in front of a child, that might be considered abuse. But I think you opened the door by your question. So objections overruled, you may continue.
thank you. Please tell the court about that abuse in front of Benjamin.
We had to stay home. So whenever we would do stuff like during the night, it's obviously, but then we would get frustrated and we would start crying. We were doing stuff.
Okay. And what would that frustration look like?
Get frustrated, I think, calm down fast enough. Tell me that I wasn't telling them to quit or something.
So Mr. Burns was telling you that you're not saying no?
Telling them to quit. Well, he doesn't comprehend words. He might say a couple words, but he doesn't know like meaning.
Okay, so Mr. Burns wanted you to tell your son to quit crying. Is that what? I'm sorry, I'm not understanding. Okay. Okay, and he was frustrated that you wouldn't say that? And when Mr. Burns would have sexual contact with you, and he would sexually assault you, the times that it was against your will, was Benjamin in the room also? While you were at the hospital between May 5th and May 12th, you started kind of getting into, in response to some of council's questions about the times that sometimes you were able to leave the immediate hospital room. Could you tell the court more about how that happened? When were you allowed to leave? Were there conditions put on that?
Just
And I kind of want to, we're asked a lot of questions about when you were around other people, when you were around from Mr. Burns. And I want to kind of group them all together. Could you tell the court the best you can why during those times, if you felt comfortable telling them and disclosing about the abuse you were going through? You were in the hospital for a few days, but was it your understanding that at some point you would go home or return to the shelter, I believe, at the time? Did you have concerns about what would happen if you had reported the assaults at the hospital? Sure. With the understanding that you were going to end up having to leave the hospital, did you have concerns about what would happen if you reported to hospital staff about the assaults? You said that on May 10th, you finally did report the assault. Could you tell the court about the circumstances that came about?
I wanted to go for a walk to make the phone call, just to get like me doing that.
Okay.
And then anyway, like, doing the corner, I seen him storm out the other day for the elevators. I'm throwing fit.
And what did you do, if anything, at that point? Okay. Did you go back to the room? Who did you end up reporting it to? Okay. And how come you felt like you could report it at that point? You testified that he had told you, when you got to the hospital to shut your phone or phones off, but at some point you were able to turn them back on to make calls.
I think I told him that I needed to at least do, check-ins.
So he let you turn the phones back on. One moment, Your Honor, if I may. Madison, you were asked about having two cell phones. How come you had two phones?
Got another one because, won't let me touch my phone. So I needed to be able to get hold of somebody in for emergency. So I had another phone stashed that way.
Okay, thank you. Nothing further. Your Honor.
How long had you had the second cell phone? From, well, hang on. When you say a few weeks or months, is that from the April 4th date or from the May date?
From then back.
From which date? April or May?
April back to March.
Somewhere, okay, gotcha. All right. And when you use the word, you said you had it stashed. Where did you keep that phone? Say again? In your desk? That was at the apartment. Okay, so you kept it somewhere around there. So when you talked about, as you testified, that he told you to put your phone up on the, was it dresser? I think it was. Was that both phones or just the one phone? That's what I was getting at. So the second phone, he did not know. So you wouldn't make calls on on that phone? Just had it in case. Pardon?
Service on it, but I wasn't able to yet, because I was trying to figure out a way to.
Say that again for me?
I was trying to put a service.
So when you say this other phone, when you're talking about putting a service on it, a plan, okay, that's what you're trying to do. So when you first got the phone, prior to your doing that with Kroger and everything, could you call from that phone? Got it. Okay. So you had to, when you had that phone, you could make a Wi-Fi call, but you couldn't make a cellular call. That makes any sense to you, but it does to me. But do you think you could call from that phone as long as you had Wi-Fi access? But what you were trying to do when you were talking about putting a plan on it, you wanted cellular service. Okay, if I'm probably getting way too technical, but you wanted service like everybody else's phone. Or, right, I mean, you just needed a plan so you could call from any, basically, if you needed to.
I wasn't sure if I was going to be able to call it out. But I decided to get it.
The plan, got it. Any questions based on the court's questions? Second.
I have a few, Judge.
Go ahead.
You, your son's on social security disability, right? Okay, and you get money monthly from the government for that? Where does that money go? Into your account? Okay, but you, okay,
Before I had my account, we had to put in his, business account.
okay, but you were receiving money.
I'm gonna.
Hold on.
The reason that I'm asking that, Judge, if I may, is because she just testified that she needed to get out of the house to put money on her card because she didn't have any money on her card. So her testimony is as if the only.
Right, but if you, just my understanding, hang on. My understanding of the time frame is that she doesn't have this other account of hers until after she leaves on the 4th.
I don't believe that's the case. Is you, I don't.
Go ahead.
If the court can ask.
But I don't think I had, that money at that time. I think it already ran out for Benjamin.
Okay, so when did that start going into an account you had?
Past year. Exactly.
Okay, but before then it was placed where? Did you have access to the business account?
Then I don't have any further questions on that, Judge.
Anything from the people? All right, Madison, you may step down. Thank you.
Remember, this witness be excused.
Any objection?
Judge, I know that it won't be convenient because I'm sure that, I know the people had inquired earlier about child transportation and childcare. I would love to be able to call her as a witness, and depending on what testimony comes out later, I don't want to be unreasonable though and say, no, she can't be excused. So I don't know.
Okay, what's her scheduling like at this point? And here's the reason I'm asking. I've got a docket as a informed counsel that was actually supposed to start at 12. I pushed that back to 1, that portion of the docket to 1. I have to get on that docket and try to do that. So I'm going to have to take a break if that's going to work with transport, because I know that here you got to get the 3 that I have. Okay. So I'm going to so here's what time is it? Thank you. Like Alexa. Anyway, what I'm going to do is we'll reconvene at 2:20. Well, just make it 2:30.
Okay.
To continue this exam, if that will work for everybody.
I'm not sure, Your Honor, I will, if you wouldn't mind checking.
I can check with the social worker and
Yeah.
officers can stay.
Yeah, I will.
They were, 10 to 8.
Yeah, Your Honor,
So did I. No, go ahead.
Your Honor's energy is unmatched, I'll say. Your Honor, I would suggest an adjournment at this point. I would like some idea of what potential, I know we can't predict what the testimony may be, but in what scenario we would bring the victim back. We can do it at a different time, but at this point, I think an adjournment would be more appropriate.
How many more witnesses do you have? I had 5 others listed, but I think you had 1 struck off that, so would I have 4 more?
So Your Honor, yes, we have a social worker and 2 officers, so 3 more.
3 more. Ms. Akinrelli, how do you feel about the adjournment? I have no
Your
idea.
Honor, we would be objecting to the adjournment. We are ready to proceed. I don't know, again, the line of questioning that may bring rise to having to call her back. But I think that if anything, we could adjourn that portion of it if need be. But I know the court obviously has to jump on this other docket, but we're here all day and ready to proceed once the court is done with the other docket.
Well, let me just say this. Part of the reason the court's in the time position that it's in is because the court was out at 9:07 ready to start. There was some delay in terms of talking with the witnesses. I'm not going to call it a delay. Prosecutor had to talk to some of the witnesses. There then arose an issue. You had to talk.
Absolutely.
And I didn't get started till whenever, trying to give leeway as best I could to the parties so that they could be prepared. There are two officers? Is that part of the difficulty is the timing of the officers and their?
I think the officers, we also have to check on the victim regarding childcare.
Okay, let's do this. I'm going to give transport time to go get my people for that docket. I'm going to have him taken back and then we'll figure out if we're going to proceed. But I got to start moving something at this point. Okay. So court is standing recess.
Don't call me.
Don't call them.
Don't leave me alone. What reason?
Oh, did you, what you end up with?
I didn't want
Oh, okay.
Yeah, yeah.
To Cleveland.
I just turned in.
Yes. So. Yes.
Cause you went to the right?
No.
Let's.
Oh, did you? Well, we're in these check.
Yeah.
Well.
Yeah. It's,
Yeah.
because it gets dirty.
Trees.
Oh, it's your car's always dirty. Oh my word. No matter what. I do. Hear you. But on the phone, that's weird. Going all over.
Nice. That's a good one. I'll have it. The hot years. Real like. That sounds good. Well,
It does sound good.
Yeah, really good. I was second.
All rise. 14A District Court of County Washington State District now back in session. The Honorable.
Good afternoon, Your Honor. Alexander on behalf of the people. Your Honor, the people raising a conflict between this honorable court and the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt. Good afternoon, Assistant Public Defender Lauren Perry of the Public Defender's Office. Likewise, does not believe the conflict exists, but if one does, we also waive.
All right, continuing the court for its part. Do not believe there's a conflict either in Michigan court rules or the case is decided there. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters against. Okay. Court does call the case of the people versus De Jure Bond Sanders.
And then on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Bond Sanders. Mr. Bond.
Deja O'Brien Bond Sanders.
Thank you.
Your Honor, as for the pretrial, we are asking to set this case for final settlement conference, please.
And Your Honor, if I could address bond when appropriate.
Jury final settlement conference will be set August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Yes.
Your Honor, it's coming to my attention. I haven't had a chance to listen to these calls, but this defendant has made 22 calls to the victim starting exclusively after he was arraigned. So at this point, I'd be asking that his phone privileges be revoked while he's in custody.
Your Honor, Ms. Senna did inform me of this, but given the fact that she nor I have listened to the calls, I would ask that you hold your ruling in abeyance until we can do so. Maybe set like another hearing before final settlement.
Well, why would I, if the calls, they were made to the alleged victim's number?
Correct. From different pins than his own.
From different pins other than,
Another inmate did call her.
was there anything else, Ms. Perry?
No, thank you.
All right. This bond will continue. Defendant's phone privileges are revoked this time. And if, I'll do it this way, if defendant requests a hearing on it, then
I'll get in touch. Thank you.
Thank you. Court does call the case of the people of the state of Michigan versus Keith Allen Davis. I can't hear you. I can't hear you. Can't hear.
Hello, on behalf of the people requesting practice under Michigan Court Law 8.120, under the supervision of Assistant Prosecuting Attorney Ali Zenda.
I heard that. Hearing no objection, permission to practice is granted. All right.
My turn?
You gonna ask permission to or what? No.
I just didn't want to interrupt.
I got you.
Yes, Your Honor, Hugo J. Mack, appearing in behalf of Mr. Davis. Mr. Davis, Your Honor, by way of information, I did get this case assigned to me very late last week, received discovery, left a voice message and a text message for Mr. Davis. I've checked the Zoom registry. I don't see him here, so I don't have a reason why Mr. Davis is not with us this afternoon, Your Honor.
Bench warrant will issue for defendant's failure to appear, bound to set in the amount of $5,000 cash surety. That warrant will issue immediately.
All right, Your Honor.
Thank you. Grisbeck. Court calls the case People versus Stephen Grisbeck.
Ali Zenda on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Michael Grisbeck.
Teresa Clare on behalf of probation. Your Honor, Mr. Grisbeck is before the court for a review hearing. At this time, Your Honor, the last report I received from the jail on his domestic violence classes is that he has completed 9 out of the 26 classes to date. There is 26 classes that he would need to complete to finish the first segment of the 52 classes. At this time, probation is recommending that the court have Mr. Grisbeck continue all the terms as previously ordered and setting a new review hearing date for September 8, 2025 at 1 p.m.
You know, we are renewing our request to allow Mr. Grisbeck to complete his probation out of custody. He did want the court to know that if he were to be released, he would be able to go back to his job. He was doing heating and cooling. He has a full-time job making $21 an hour. If he were to be released, he could start as early as Wednesday. He also did, per the court's recommendation, he did get in touch with the reentry program regarding his Section 8 housing. And his Section 8 housing, he believes, is still valid if he were to be released. So he would have his voucher still, which is great news, as I think we were all concerned about him, the possibility of him losing it. He's also very eager to get out and care for his children. He has 2 children. His son's birthday is actually this Wednesday. As of today, custody, he would, as the court knows, he has a 24-month probation term, so he would be under supervision for quite some time. He has completed 9 classes, and if he were to be released, from his understanding, this court could order him to restart the program, which would mean another 52 weeks of the DV case or class, which he is willing to do.
My big question is if I go to September 8th, where's he going to be class-wise? Because that's part of.
I did speak with the class instructor, and he indicated to me that the defendant's participation in work is just okay. He's not going above to get the class done. He has not shown up to class. He just hasn't gone. So if Mr. Grisbeck was interested in getting out so he could do the site, it seems that he would put forth the effort to get the first 13 weeks done on the inside. I mean, theoretically, to get 26 classes done, he only has to go for 13 weeks. So, because they do it twice a week on the inside. Now, I don't have an exact number where he didn't do that, but according to Mr. Henderson, who runs the class inside the jail, he's just not putting forth the effort.
I do know, Gunnar, it's hard to say also how many classes or how many weeks in the future, because I do know the class, if the teacher is ill, isn't held, if there's a holiday or a jail lockdown. So, yeah, so the court knows, there are situations where the class isn't even held.
Today, the class is canceled as well. And then there's been times where, like I said, they didn't come get us for class. We were on lockdown. I mean, I've been trying to get this class done, every possible class there is.
All right. What I'm going to do is I'm going to continue all terms as previously ordered. I'll set the next review hearing for September 8, 2025 at 1 p.m. What I'd like to see is some indication that I think we can probably get from either Mr. Henderson or the jail as to the defendant's attendance. And I'd like to see that laid out for me to see whether or not it's a circumstance where classes are being canceled or the defendant's not going.
Okay, Your Honor, I will
All right.
have to report for Mr. Henderson.
All right. Thank you. Court does call the case People versus Austin on.
Hello, on behalf of the people.
Assistant Public Defender Natalie Davis on behalf of Mr. Austin On, who should be present via Zoom. Sir, could you please unmute and state your name for the court?
Austin On.
Oh, there he is.
Thank you, Your Honor. I'm respectfully requesting a brief adjournment so that I can continue reviewing media discovery and then discuss that with the client. And I do believe Ms. Zenda states that the 911 call is also still on the way.
That's correct, Your Honor. No objection to the adjournment.
It's amazing when they're little and they get their voice. Free trial in this matter will be adjourned to.
August 4th at 1 p.m.
Okay, August 4th, 2025, 1 p.m.
Thank you, Your Honor.
Thank you.
You're on. You're all set for today.
Okay, thank you.
Case People versus James Raggett.
Ally Zend on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Raggett, who is approaching. Mr. Raggett, can you please state your name for the record?
James Patrick Raggett III.
Regarding the pretrial, we're asking to set this for final settlement, please.
Jury final settlement conference, August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you.
Thank you. Court does call the case People versus Anita Payne.
Hello, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Ms. Payne. Ms. Payne, please state your name for the record.
Good afternoon, Your Honor. My name is Anita Payne.
Thank you. All right, what are we doing?
Teresa Claire on behalf of probation, Your Honor. Ms. Payne is before the court for hearing. Ms. Payne is compliant with the terms ordered, accepting with her payment. She did have an arrearage of $113. She did indicate to my office that she would have that paid, and I'm just checking right now by today's hearing. And she has made that payment, Your Honor.
Okay.
Given that she is now compliant with all terms, probation is recommending that she remain compliant with the payment plan of $69 per month, that she continue all other terms as previously ordered, with the next review hearing being set October 6th, 2025 at 1 p.m.
Your Honor, I did speak with my client regarding this. I don't have any objection to any, the majority of it. The only thing we would like to address is the contact order. There is a no contact order with the child and I suppose the child's father. It's been in place since the start of this case. Ms. Payne would like to have contact with, I suppose both of them, as the child is living with the father, but specifically the child. I did look back at my notes when the father was present at sentencing back in April. He did say he had no objection to them having contact. It seems Ms. Payne has been compliant with probation, is attending programming, and that seems to be going well. So we're just asking for the court to consider lifting that no contact order so she can have contact with her son.
And Your Honor, I would defer to the court with that. However, I do believe the reason that was put in place is because there was a circuit court order that directed the state.
and that's what I recall. And my question is has anything changed regarding the circuit court order?
I have not received anything to the contrary that it's been different.
Is it PPO?
They have a custody or a court case at circuit court.
Well, Your Honor, I don't know.
Fair.
Yeah, I don't know. I can't answer that, but I'm happy to.
Go
Sure,
ahead.
Ms. Payne, do you know?
Is it okay if I speak real quick?
Yeah, go ahead.
Hi, how's everybody doing today?
Good. Thank you.
Wonderful. So right now on custody, there is not parenting time set for my son just yet. I have not applied for that because I was on probation for this case, and I didn't know how that was going to go through with them either awarding it to me or not awarding it to me for me being on probation for the case. So I was hoping to wait until it was over to apply for custody, but I don't have any parenting time implemented. But with the no contact order is only through this court right now. There's nowhere else that says I can't see him. And his dad said that it's fine for that, but it makes it difficult when in the paperwork from probation says that there's a no contact. That's the only place that it says that. And I don't think that personally that me seeing him is going to be a danger. I understand what happened and I just want to see him. He needs to see me as well. And thank you so much.
Ms. Hilary, you were going to say something.
Your Honor, I pulled that language from what was last in their custody order. I don't think that anything.
Basically, this did not allow.
It basically allowed for supervised visitation.
Yeah, right.
At his home. Now, there is a no contact order with Mr. Robertson, which would prohibit Ms. Payne from visiting the child with his supervision, which was what was allowed by circuit court. So I do believe, Your Honor, that it would require some motion on Ms. Payne's part to have that order changed.
At circuit.
Correct.
Yeah.
So
I don't think that this was derived, I can stop there because I don't think it was derived out of the blue. I think where it came from was whatever was put in place
at circuit
court. That's where we got it. So if somebody wants to get something to me, Ms. Perrone, that shows me that the circuit court order is something different, I will certainly reconsider that.
Yeah, family law is pulled other bear. So I'll have another conversation with Ms. Payne.
I gotta be a bear.
It's a bear. I don't really,
okay.
us criminal attorneys don't always want to touch, but I'll see if we could do something up there and Ms. Payne and I can get more information to the court.
All right, very good. I will then order that the defendant's payment plan at $69 per month will continue. I'll continue all other terms as previously ordered. I'll set our next review hearing October 6, 2025 at 1 p.m. Thank you.
Thank you, Your Honor. Have a lovely day.
Thank you. You too. Court does call are both on?
Yes.
Cases of the People versus Roman Williams.
Claire Law on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perrone on behalf of Mr. Williams.
He's in Zoom, Your Honor.
No. State your name, please.
Roman Williams.
Just Claire on behalf of probation, Your Honor. Mr. Williams is before the court for review hearings in 2 cases, one ending in 1236 and the other ending in 1243. Mr. Williams is non-compliant with the payment plan that's set forth in both cases. The other issue with Mr. Williams, probation is asking that the court give him a warning about attending the domestic violence class weekly. He's still considered compliant, but is really pushing towards his max of absences. So probation's asking that the court give him a warning about attending that DV class weekly without skipping, and that in case ending in 1236, that he pay $77 arrearage today, then remain compliant with his payment plan of $26. To the case ending in 1243, probation's asking that he make a payment of $997 arrearage today, then remain compliant of his payment plan of $181 per month. And in both cases, have the court have him continue all other conditions as previously ordered, with the next review hearing date being set August 8th, 2025 at 1 p.m.
I don't have really an objection to any of that. I was unable to speak with Mr. Williams prior to today. Mr. Williams, I think the number we have for you is disconnected. So if you've changed your number, please call the public defender's office. And so we can contact you, okay?
Okay.
Did you get my email?
Yes, I received your email.
You can also call my number and my signature. But I'm not sure if Mr. Williams is able to pay that today. But again, no objection to anything else. Mr. Williams, are you able to make a payment today?
I'm able to make a payment towards both of them, but maybe not the entire $977.
How much can you pay?
Probably like $300, $200.
Well, we'll go with the 3 because you're behind. So I'm going to order on the case ending in 1236 that the defendant is to pay a $77 arrearage on or before today's date, then remain compliant with payment plan at $26 per month. I will admonish the defendant that he is to attend his domestic violence classes weekly. And I'm just going to let you know, if you get kicked out of the domestic violence program, that could lead to incarceration for yourself. You understand me?
Yes, sir.
Continue all terms as previously ordered. I'll set the next review hearing for August 18th, 2025 at 1 p.m. That's on that case. On the other case ending in 1243, the defendant is to pay $223 arrearage on or before today on that case. How are you going to get yourself back on track on this case, young man? Because then you're going to owe about $774 still on that case just to get compliant.
I'll just probably put like $100 every week. Yeah, try to get myself caught back up. Just because I know it is like $181.
What I'm going to do is you're to pay $223 today. That comprises the other half of that $300.
Okay.
And then $100 per week thereafter until compliant.
Sounds good.
And then you have to remain compliant. On this case, I'll do the same admonishment regarding your attendance at DV classes. I'll continue all terms as previously ordered. I'll set its next review hearing August 18, 2025 at 1 p.m. Thank you. Court does call the case of the people versus Zachary Burlett. Yeah, Mr. Burlett's here.
Mr. Burlett, please state your name for the record.
Zachary Thomas Burlett.
Joyce Claire on behalf of probation. Your Honor, Mr. Burlett is before the court for a review hearing. Mr. Burlett did have a relapse. So Mr. Burlett did find himself back into Dawn Farm Sparrow.
Okay.
And he did go in to Sparrow on June 12th. He completed his detox on the 15th. Then he went over into the residential portion, which is where he still is. The plan is on the 13th of this month to move back into transitional housing. The one thing that I can say about Mr. Burlett, although he did have that relapse, he's been in communication with my office. At this time, probation would like the court to give him an opportunity. As the court's aware, substance abuse issues is a difficult. The biggest part with probation is that Mr. Burlett let me know about it right away, and he is honest about it. Given that he did that, at this time, probation's asking that the court order Mr. Burlett to start with payments, resetting them at $133 per month beginning in August on the 11th, that he complete his 30-day inpatient at Dawn Farm, then can comply with the plan for transitional housing and continued outpatient. That plan is for long-term, Your Honor. And that he continue with all other conditions that this court set forth, with the next review hearing date being set August 18th, 2025 at 1 p.m.
All right. Mr. Burlett, anything you want to tell the court?
Yes, Your Honor. First of all, I want to thank Agent Blair for being very supportive of my recovery, and I'm grateful that that everyone that is in my corner is not looking for punishment, because that's not what this is about right now. It's just about getting back on the ball with things and going through the level of care here and where the mistakes have happened, where I wouldn't say, not trying to beat myself up, where I take part in my part of everything, if I'm making sense here, and that, you know, just having to redo things in a certain different way, like with employment, we're going to go to part-time. I have my commitments back at certain meetings that I've been having commitments at. Have to apply myself a little more, you know, not to be so hard on myself. So I really want to thank Agent Palera and the courts for giving me the privilege to continue my sobriety, and more importantly, to really be in my corner of it. It's truly amazing. But again, I take my part in everything. And, you know, again, Agent Players remind me that, you know, she's not here to punish me. She's here to help me as much as that she can possibly, as long as that I work with her, but more importantly, be honest with her. And that's the one thing that I have to learn in my recovery, more importantly in life, that I have to be honest within myself and with others, because that's what's going to help me achieve my goals and have achievement in my sobriety. So thank you for letting me speak.
Probably the thing that sums up Ms. Palera is when you said she's amazing, and she is. That's why I'm so proud to have her as my probation. It's supposed to work this way when something like this happens. Most important thing for us, quite frankly, is get you back on track. Give you an opportunity to sort of breathe and move forward. Like you said, it's not about punishment at this point, certainly. All right. So
Yes,
I'm going to order that. Let's pay $133 per month. We'll begin at August 11th, 2025. He's to complete 30-day inpatient at Dawn Farm, then comply with the plan for transitional housing and continued outpatient treatment. All other conditions as previously ordered. I'll schedule a review hearing August 18th, 2025. 1 p.m.
1 p.m. Thank you.
Right.
Really quick, Your Honor, I know we're trying to move along here. There has been a situation that came to my attention from one of my peers, and I did bring it to Agent Palera's attention. She was not aware of it, not to throw her under the bus. We did discuss about it. There is an active case that was open on June 4th for a retail fraud.
For you?
And yes, and I'm being very honest about it. I did not receive any type of mail, anything about it. I've asked my roommates if anything have came in.
Hang on a second, Mr. Burlett.
I believe that it will be coming to you. It is not a violation of his probation. It is from June 4th.
It's from June 4th.
Before he was placed on.
Before he
I
was.
believe of 24. So it's just coming through now.
It's just coming through now to me. Okay. All right. Well, thank you for that, but we'll deal with it when it gets here. It's not a further violation. You were in the throes of whatever the heck you were trying to do with your life when that happened. Okay. So
yes,
we take that into consideration.
Yes, Your Honor. Thank you.
All right. We'll see you. Take care of yourself.
You too. Thank you as well. Thank you, Agent Player.
Court calls the case, People versus Timothy Riley.
On behalf of the people, this is Public Defender Natalie Shea on behalf of Mr. Riley's appearance is waived.
Teresa Clare on behalf of probation. Your Honor, Mr. Riley was scheduled before the court today for a review hearing. He is compliant with all terms ordered by the court. Mr. Riley has actually completed everything that this court has ordered. At this time, probation is asking that the court discharge him from probation of his case. So, yeah, with improvement, Your Honor.
All right. Thank you. Not hearing an objection. Defendant is discharged from probation with improvement. This case will close. Court does call the case of People versus Jason Stevens.
Under Natalie Pitt, Mr. Stevens, Eric Wade.
Teresa Claire on behalf of probation, Your Honor, Mr. Stevens was scheduled before the court for a review. Hearing he is compliant with the terms ordered by this court. Probation is recommending that all conditions continue with the review during the 2025 at 1 p.m.
No objection.
So ordered. Court does call the case of the People versus Marco Arizankowski.
Claire on behalf of probation, Your Honor, Mr. Eric Zinkowski was scheduled before the court today for a review hearing. He is compliant with all terms ordered by the court, and I did waive his appearance. Probation is recommending that all the next review hearing be set October 6, 2025.
Objection, so ordered. Court does call the case of the People versus BJ Dandamoody.
Teresa Claire on behalf of probation, Your Honor, Mr. Dandamoody was scheduled before the court today for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Probation is recommending that all conditions continue with the next review hearing being set.
Hearing no objection, so ordered. Court does call the case of the People versus Robert Jones.
Teresa Claire on behalf of probation.